Hello everyone, and welcome to our second Employment Monthly Update. This month, I'm going to provide you with a quick update on recent developments in the arena of worker status. The debate about the status of gig economy type employees rumbles on, and I'm going to summarise first of all for you the recent decision in Stojsavljevic and DPD. Outside of the gig economy sphere, I'm also going to talk to you about the decision of Nursing and Midwifery Council in Somerville, which came out only last week. That involves the status of an individual who sat on and chaired the Nursing and Midwifery Council's fitness to practice panels. So first of all, Stojsavljevic, which was a decision of the EAT. The claimants were drivers for DPD and had contended before the tribunal that they were workers or alternatively employees under the relevant parts of the Employment Rights Act and the Equality Act. Both claimants had entered into DPD's standard form written franchise agreement. While DPD contended that the claimants had been independent contractors, each claimant contended that the reality of the agreement had been that he had contracted as an individual driver, solely and personally responsible for the delivery and collection services he had agreed to undertake. That argument did not succeed in the tribunal, and the claimants appealed. In the EAT, Mrs. Justice Ellenbogen dismissed the claimants' appeal, endorsing the tribunal's conclusion that the claimants were self-employed franchisees rather than workers or employees. The parties had agreed that the only issue for the tribunal, and subsequently the EAT, was that of personal performance. So whether the claimants had an unfettered right of substitution or not. So as a result, other issues were not considered. In short, it was common ground between the parties that a genuine right of substitution, which is inconsistent with personal performance, is also inconsistent with both employee and worker status. The claimants appealed to the EAT on 3 grounds, and they started by addressing the court on the 3rd ground, that the tribunal failed to take account of relevant matters or give adequate reasons when finding that the franchise agreement represented the genuine agreement between the parties. The claimants argued that there was no unfettered right of substitution under the agreement. They said a driver franchisee could only sub in a driver from the existing pool of drivers. The problem, said the claimants, was that the tribunal had confined its analysis to the franchise agreement and failed to examine all the circumstances to determine the actual agreement between the parties, as was required by the case of Autocleanse and Belcher. DPD unsurprisingly disagreed and said that the franchise agreement was a genuine commercial agreement under which franchisees could substitute personal performance with performance by a nominated driver of their choice. In her decision, Mrs. Justice Ellenbogen found that consistent with the approach set out by Lord Legh and Uber, the tribunal did not start from a legal presumption that the franchise agreement contained the whole of the parties' agreement. The tribunal had correctly also looked at how the relationship between the parties operated in practice and had concluded that the franchisees had been able to substitute personal performance to a person of their choice. She also agreed with the tribunal that the claimant's use of only other franchisees or franchisee drivers as cover drivers was no more than a practice and didn't detract from their broader contractual entitlement. That was consistent with Lord Clarke's 3rd proposition in Autocleanse, where he had stated at paragraph 19, if a contractual right, as for example a right to substitute exists, it does not matter that it is not used. It does not follow from the fact that a term is not enforced that such a term is not part of the agreement. Further, the judge agreed with DPD that to overturn the tribunal's conclusions on the facts, the claimants would need to successfully argue that the findings made by the tribunal were perverse. That was, of course, a high threshold, and the claimants had not even sought to advance their case on that basis. Accordingly, the judge rejected the claimant's 3rd ground of appeal. The judge then turned to consider the 1st and 2nd grounds of appeal. Under ground 1, the claimant said that no basis had been identified upon which a term could be implied into the agreement to the effect that the franchisees might have an unfettered right to substitute drivers. They said that such a term ran contrary to section 18 of the operating manual, if indeed it was incorporated, which set out a list of requirements for a driver to be approved. Secondly, under ground 2, the claimants said that the tribunal failed to take account of section 18 of the operating manual. The judge took these grounds together. She started by looking at the franchise agreement and the operating manual and found that the following matters were clear. First of all, the franchisee is appointed to operate the business. Secondly, the business is defined to include the supply of a driver. Thirdly, the definition of driver encompasses anyone who satisfies its requirements. And fourthly, the franchisee has a duty to operate the business in accordance with the operating manual and to provide or procure training as required. Taking everything together, the judge held that section 18 of the operating manual was not incorporated as a term of the agreement. If she was wrong about that, however, looking at the detail, section 18 simply went to the contractual definition of driver, and in the absence of any clause broadening DPD's right to decline to authorise someone, each franchisee was contractually entitled to provide services by using a driver, which might or might not include himself or herself. In all the circumstances, therefore, the judge found that no interpretation of the express terms of the franchise agreement inconsistent with their natural and ordinary meaning was necessary. The remaining question was then whether, properly construed, the agreement imposed a fetter consistent with a requirement for personal performance by the franchisee. In Pimlico Plumbers in the Court of Appeal, Sir Terence Etherton had summarised the applicable principles and had said, fourthly, a right of substitution limited only by the need to show that the substitute is as qualified as the contractor to do the work, whether or not that entails a particular procedure, will, subject to any exceptional facts, be inconsistent with personal performance. The judge found that the franchise agreement fell within that category for the following reasons. First of all, she said that the right to pass on an entire job is inconsistent with personal performance. Secondly, here there was no requirement that the driver be of a particular type or identity. The driver simply needed to satisfy the generic condition. Unlike the position in Pimlico Plumbers, there was no requirement that she or he come from the ranks of the existing operatives who are bound by the same obligations of the franchisee. Any driver needed to satisfy the contractual definition of that term, but it mattered not whether he or she was a franchisee, a previously approved driver, or just a particular individual. The driver simply needed to be qualified and trained to undertake the work. As was the case in Deliveroo, that created a large pool of eligible people, and the fact that it included an application procedure was irrelevant as a matter of law, as set out in Sir Terence Etherton's fourth principle. The judge found the claimants could delegate their functions as driver, subject to DPD being satisfied that the minimum requirements necessary for the service to be delivered to customers was met. Finally, DPD had no absolute and unqualified discretion to withhold consent, provided an individual met the definition of driver in the contract. So in Stojsavljevic, all three grounds of appeal were dismissed by Mrs. Justice Ellen Bogan, and she held that there was a genuine right of substitution, which was inconsistent with personal performance and inconsistent with worker and employee status. Turning now to the second decision, that of Somerville. In this case, the Court of Appeal considered the question of whether an individual who sat on and chaired fitness to practice hearings was a worker within the meaning of the Working Time Regulations 1998. The claimant, Mr. Somerville, sat on and chaired the Nursing and Midwifery Council's fitness to practice committees for 2 4-year terms. In 2018, he claimed unpaid holiday pay on the grounds that he was a worker and entitled to paid annual leave under the regulations. The tribunal ordered a preliminary hearing to decide the worker issue. Before we go any further, I think it's just useful to remind ourselves of the wording of the regulations. So under Regulation 2.1 of the Working Time Regulations 1998, worker means an individual who's entered into or works under A, a contract of employment, or B, which is the relevant one here, any other contract, express or implied, where the individual undertakes to do or perform personally any work or services for another party to the contract whose status is not, by virtue of the contract, that of a client or customer of any professional business undertaking carried on by the individual. The claimant's appointment was subject to written terms of agreement, which were referred to by the court as the overarching contracts. The claimant also agreed, i.e. he contracted, to sit on panel hearings on particular days, although he was free to refuse to accept any particular hearing date or cancel a hearing that he had already agreed to by notifying the council. The tribunal held that the claimant was a worker within Limb B of Regulation 2, as in addition to the overarching contracts, there were these individual contracts when hearings were assigned to the claimant and under which he agreed to provide his services personally. And of course, the council was not a client or customer of a professional business that he carried on. The council appealed to the Court of Appeal on the basis that an irreducible minimum of obligation was necessary for worker status. So in effect, they were trying to argue that there was a need for an obligation on a claimant to perform a minimum amount of work in order for a contract to be a worker's contract. The Court of Appeal rejected that submission. It agreed with the tribunal and the EAT that the individual contracts which the claimant entered into each time the council offered a hearing date and the claimant accepted it were contracts to perform work personally, and that the council was not a client of the claimant's business or undertaking. Those findings were sufficient, and there was no need and no purpose served by introducing the concept of an irreducible minimum of obligation as contended for by the council. That was consistent with the Supreme Court's decision in Uber, said the Court of Appeal, where the drivers were not claiming to be providing services under any overarching contract between them and Uber, as indeed that would be inconsistent with the fact that the drivers were entitled to decide when, how, and how much to work. They were, however, providing services under individual contracts when they were working. Properly read, said the Court of Appeal, paragraphs 124 to 130 of Uber, which were relied on by the council, are directed towards identifying the time when the obligation to perform work arose. They are not intended to suggest that even when a person is working or providing services personally under a contract, there must be some superadded distinct obligation on an employer to provide work or an individual to accept work before that can fall within Limb B of Regulation 2. The fact that the claimant could withdraw from the agreement to attend a hearing even after he had accepted did not change anything. Fundamentally, the claimant had entered into a contract which existed until it terminated. Finally, the court added that the overarching contracts were not workers' contracts. They did not impose any obligation on the claimant to do work or perform services personally. So both Stojsavljevic and Somerville serve as useful reminders of the court's approach to the issue of worker status. As these two decisions show, the battleground will often be in respect of personal performance versus right to substitution, and the decision will always be rooted in the wording of the agreement and the function of the relationship in practice. Thank you very much. If you have any questions, please do feel free to get in touch using the email address on the screen. And please look out for our next monthly update, which will be published in early April.